Hi everyone, I am Kanchan from VSLLS Webs and I'm taking your administrative law classes. I hope all of you are doing well and taking care of your health. Now, today we'll be studying about the doctrine of necessity, and this doctrine you can say is a kind of an exception to the rule against bias. It says that whenever the situations are unavoidable, that it becomes necessary to decide and there is no other competent person to decide, then the rules of judicial propriety need to be set aside and decision must be taken. So therefore, even though you may have certain doubt that the person who is deciding your case is biased, but then you have no other option and a decision need to be taken. Therefore, it says that instead of no decision being taken at all and instead of completely stifling the process of justice delivery system, it's better that justice must be done and the decision must be taken. Okay, so this is about the doctrine of necessity. As the name suggests, necessity, there can be circumstances which are very important. It rendered no other option to us, and therefore even though we feel that we have a doubt or some kind of idea that there can be biasness in the decision, but still we follow the suit and we give the authority to person to decide that particular case. Okay, so the first case of Ranjeet Thakur versus Union of India. Now, in short, generally, Ranjeet Taku is a person, is an army personnel, and he was not happy with his commanding officer, so he said certain representations regarding his army officer to his seniors. Now, for violating such service rules, because this is something in violation of the service rule, so he was being punished for the same act, and the commanding officer has only decided his case and sent him to 28 days of custody, wherein he was being handcuffed and he was put in a different cell altogether. While he was serving this particular sentence, he also did another offense, and the offense was that when food was served to him by the subedar, he denied and he said that I'll not take the food. Now, therefore, it was decided that court martial should be done. Now, while composing the bench of the court martial, the commanding officer was a part of it. And in one of the provision of the Army Act, it was very specifically stated that whenever you constitute a court martial bench, therein you need to take the opinion or objection of the person against whom you are proceeding. So, therefore, in this case, you will learn two things. One is that how important it is to follow the rules of procedure which is prescribed in a particular statute, specifically in the circumstances that we'll see here, that when you are removing a person from his post, you are asking person to leave from a particular employment. Okay, or the cases of court martial, this is a very specific case of court martial, but in general I'm saying that generally when employees being asked to leave the service, or there is a matter of crucial importance, how it becomes pertinent to follow the rules that are being prescribed in the procedure which is laid down in the statute. That is one. Second, on the administrative law aspect, that is rule against bias. And although in some of these cases the doctrine of necessity as such is not mentioned, but yes, the doctrine of necessity is also being implied in some cases. So therefore, in this particular case, the doctrine of necessity actually arose from this contention of the parties that it was necessary for the commanding officer to be the part of the quorum of the bench which has to proceed against Ranjeet Thakur in the court martial. So this contention was not been accepted by the court in this particular case, saying that it amounted to real likelihood of bias was definitely there, and therefore it was necessary that the commanding officer should not be a part of the bench which was proceeding against Ranjeet Thakur. So on both these grounds, that is one, that you have not followed the procedure which is there, and secondly on the ground of bias, the decision or the formation of the bench was being set aside in this particular case. Okay, so should we read the facts? Let's directly come to the decision. So on procedural safeguards, what's been said? It says the records of the proceedings of the special summary court martial do not indicate that the procedural safeguard against bias, which is contained in section 130 of the act, was complied. So section 130 in itself is a good tool or a weapon in the hands of Ranjeet Taku, because it very specifically gives you the idea that rule against bias is entrenched in this particular provision. So section 130 says, at all trials by general district or summary general court martial, as soon as the court is assembled, the names of the presiding officer and members shall be read over to the accused, who shall thereupon be asked whether he objects to being tried by any officer sitting on the court. Okay, so he'll be given an opportunity, he'll be made to know that who all are proceeding against him. So, if the accused objects to any such officer, his objection and also the reply thereto of the officer objected to shall be heard and recorded, and the remaining officers of the court shall, in the absence of the challenged officer, decide on the objection. Okay, so if he objects to any such officer, then his objection will be taken care of, it be recorded and be accordingly decided by other officers. The proceedings do not indicate, this was not disputed at the hearing, that appellant was asked whether he objects to be tried by any officer sitting at the court martial. This, in our opinion, imparts a basic infirmity to the proceedings and militates against and detracts from the concept of a fair trial. तो यहाँ पर they are saying कि ये तो बहुत क्लियरली स्टैब्लिश हो रहा है कि 130 को आपने फॉलो नहीं किया, एंड देयरफॉर इट इज़ अगेंस्ट द वेरी आइडिया ऑफ अ फेयर ट्रायल. I'll directly come to what, because they have quoted opinions of some great people here. Great Justice Frankfurter. So he's saying, if dismissal from employment is based on a defined procedure, even though generous, beyond the requirements that bind such agency, that procedure must be scrupulously observed. This judicially evolved rule of administrative law is now firmly established, and if I may add, rightly so, he that takes the procedural sword shall perish with that sword. The history of liberty has largely been the history of observance of procedural safeguards. So, that much has been said about procedural safeguards. So, we are afraid the non compliance of the mandate of Section 130 is an infirmity which goes to the root of the jurisdiction and without more vitiates the proceedings. So, on that particular ground, they have already observed that the proceedings were not fair. Now, on the ground of bias, let's see what they have to say. The test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and is whether respondent number 4 here is the commanding officer of this Ranjeet Thakur, was likely to be disposed to decide the matter only in a particular way. It is the essence of a judgment that it is made after due observance of the judicial process, that court or tribunal passing it observes at least the minimal requirements of natural justice, is composed of impartial persons acting fairly and without bias and in good faith. Now again, I'll try to emphasize this thing, that the commanding officer was the one against whom Ranjit Thakur was having the grievance and against whom he has complained to his seniors, right? And then commanding officer was the person who has given him 28 days of imprisonment, and therefore he was the same person who will be part of the quorum which will be constituted to proceed against Ranjit Thakur in the court martial. Okay, so that's the problem here. It's the essence of a judgment that it is made after due observance of the judicial process. I think we have read that. No, that the court or tribunal passing it observes at least the minimal requirements of natural justice. Yes. So a judgment which is the result of bias or want of impartiality is a nullity, and the trial is quorum non judice. Okay. So we've already explained the concept quorum non judice. That means as if the decision has not been taken because the judge was not having the jurisdiction at all to decide the case. Then they have quoted the opinion of Lord Denning in one of the cases, and he has said, in considering whether there was a real likelihood of bias, the court does not look at the mind of the justice himself or at the mind of the chairman of the tribunal or whoever it may be who sits in a judicial capacity. It does not look to see if there was a real likelihood that he would or did, in fact, favor one side at the expense of the other. The court looks at the impression which would be given to other people, even if he was as impartial as could be. Nevertheless, if right minded persons would think that in the circumstances there was a real likelihood of bias on his part, then he should not sit. Okay, so what's the standard? I think through all these cases, you should by now learn these phrases, right? It should be there in your mind that how do you decide? You have to decide it from the perspective of the right minded people, like according to him whether the person would have suffered a bias or not. So we'll not evaluate the mind of the judge or the chairman of a tribunal. We'll rather evaluate the mind of right thinking people in the society. Now, who are the right thinking people in the society? We generally call them to be a reasonable people who, if placed in those circumstances, having the relevant material, would think in a particular way, right? Not very sensitive people, weak minded people, fickle minded people, not those people. Okay, so this test you should remember by now. Then again, Justice Frankfurter is being quoted in another case, and they're saying the judicial process demands that a judge move within the framework of relevant legal rules and the court covenanted modes of thought for ascertaining them. He must think dispassionately and submerge the private feelings on every aspect of a case. Okay, there is a good deal that the judicial robe does not change the man within it. It does. The fact is that, on the whole, judges do lay aside private views in discharging their judicial functions, and this is achieved through training, self discipline, and that fortunate alchemy by which men are loyal to the obligation with which they are entrusted. But it is also true that reason can't control the subconscious influence of feelings of which it is unaware. When there is a ground for believing that such unconscious feelings may operate in the ultimate judgment or may not unfairly lead others to believe they're operating, judges refuse themselves. They do not sit in judgment. So he's just trying to tell what is the general nature of people who decide the cases, the judges or the chairmen of the tribunals, that they act in their official capacity. They do not act in their individual capacity, and whenever they feel that their subconscious may affect their reasoning, in those cases they recuse themselves. So this is the entire reasoning that's been given by the court. They have quoted from various authorities, and finally what they have decided: accordingly, the participation of the commanding officer rendered the proceedings quorum non-judice. The court also found the punishment awarded to be strikingly disproportionate to the offense committed. As a result, the appeal was allowed and the proceeding of the court martial and the subsequent orders were quelled. So here also the doctrine of proportionality has been invoked. Now, doctrine of proportionality is something that you are reading nowadays a lot many times, and specifically after the judgment that was being given in the Swamy case. Okay, and recently I think the Supreme Court, with respect to the use of virtual currency in India, they have rendered the decision that was being taken by RBI to completely prohibit the use of virtual currency. It's being said that it is something which is disproportionate, right? So doctrine of proportionality, you should know that what is it and in what cases can it be invoked. Could be a good tool in the hands of the lawyers as well. Okay, now let's come to the other case, that is Ashok Kumar Yadav versus state of Haryana. Ashahan, in this thing again, when I'm saying disproportionate, there's one fact which I missed, which was that they have actually decided in their court martial proceedings that now this Ranjeet Taku, he'll not be given any opportunity to even get employment in the civil society also, and he will not be able to get any civil employment as well. And also he was being put into rigorous imprisonment, and he was handcuffed. So all these things was considered to be excessive and not according to the crime or the offense that he has committed. Was disproportionate. The sentence was disproportionate with respect to the offense with which he was charged, or the offense which he has committed. Okay. Okay, so the second case is Ashok Kumar Yadav. So this case will tell you that generally very statutory, or the bodies which have a constitutional status, generally when we impute this doctrine of rule against bias, it's not applicable there generally. So therefore the decision of the election commission with respect to any politician, or the decision of the speaker with respect to the disqualification of the members of the assembly, or the lok sabha, or decision of the public service commissions is generally being held to be valid on the grounds of doctrine of necessity. So, two things, there'll be 2 points that I've said. One is with respect to the decisions that are being taken by the Election Commission, and this case pertains to the decision that are being taken by Public Service Commission. So, these two aspects are covered in the notes. The third aspect, that the decision that is being given by Speaker is generally uh, called to be valid, because it's been said that you have no other forum but the speaker will decide the case. Now again I'll just bring to your notice that and I'm sure that you must also be aware of this, that there has always been a controversy regarding the post of the speaker. And recently Justice Rohinton Nariman, he has remarked and suggested to the parliament that now it's the right time that a separate tribunal should be constituted to decide the cases of disqualification, specifically under Schedule 10, right? So because speaker in our country, he does not leave his political party, so he's always affiliated to his political party. And therefore specifically when in the matters of state emergency under article 356, these matters arise. Recently in Maharashtra, or could be in Karnataka, and in fact MP, the case of MP. So the position of governor and speaker is always into controversy. Okay, this is just to the facts, general awareness, and nothing to do with the case. I'm just telling you that this is a general trend that is there. But generally when it comes to the court tries to preserve the sanctity of post, and therefore the decisions that are being given by them are hardly, generally the trend is, the they try to keep the sanctity of the post, and therefore they do not declare their decisions to be as such invalid unless the situations are such. For example, it happened in the this northeastern state of Arunachal Pradesh. Okay, you can read more about all these happenings. It's the right time for you to study these things. Okay, let's come to the case. Now, in this case, actually, the some of the relatives of the Public Service Commission members have participated, and therefore the allegation was that at the time of the interview, these people had certain kind of a bias, definitely, because their relatives have participated in the exam of Public State Service Commission of Haryana, and instead of recusing themselves, they were somewhat related in the entire process, so it may have affected the selection of the other people. So that was one of the contentions of the parties, but was not accepted by the court in this case. Let us see on what ground they have refuted the allegations being made. Okay, so on bias, what they have to say, it is one of the fundamental principles of jurisprudence that no man can be a judge in his own cause, and that if there is a reasonable likelihood of bias in accordance with natural justice and common sense, that the justice likely to be so biased should be incapacitated from sitting. The question is not whether the judge is actually biased or in fact decides partially, but whether there is a real likelihood of bias. What is objectionable in such a case is not that the decision is actually tainted with bias, but that the circumstances are such as to create a reasonable apprehension in the mind of others that there is a likelihood of bias affecting the decision. The basic principle underlying this rule is that justice must not only be done but must also appear to be done, and this rule has received wide recognition in several decisions of the Supreme Court. The same thing. The principle which requires that a member of a selection committee whose close relative is appearing for selection should decline to become a member of the selection committee or withdraw from it, leaving it to the appointing authority to nominate another person in his place, need not be applied in case of a constitutional authority like Public Service Commission, whether central or state. ठीक है, तो बोल रहे हैं कि जो रूल्स बाकी सिलेक्शन कमिटीज़ में अप्लाई होते हैं वो पब्लिक सर्विस कमीशन जैसी अथॉरिटीज़ जो कि एक कॉन्स्टिट्यूशनल बॉडी है उन पर अप्लाई नहीं होंगे, चाहे वो पब्लिक सर्विस कमीशन स्टेट लेवल का हो चाहे वो यूनियन लेवल का हो. ठीक है. If a member of the Public Service Commission was to withdraw altogether from the selection process on the ground that a close relative of is appearing for selection, no other person save a member can be substituted in his place. And it may sometimes happen that no other member is available to take the place of such member and the functioning of the Public Service Commission may be affected. Okay, so what they're saying that they're just giving a practical example that if every time these kind of allegations will be put on, then in that case it will be very difficult for the Public Service Commission to function, and there may be circumstances where no other member is available to be a part of the Public Service Commission. So in that case, how the PSC will work. Okay, so when two or more members of Public Service Commission are holding a viva, they are functioning not as individuals but as the Public Service Commission. Of course, it must be made clear that when a close relative of member of PSC is appearing for interview, such member must withdraw from participation in the interview of the candidate and must not take part in any discussion in regard to the merits of the candidate, and even the marks or credits that are given to that candidate should not be disclosed to him. So they are saying that this could be a general good ideal conduct that can be followed. And finally, they are saying in the instant case, both the members of the Haryana Public Service Commission retired from the room when the interviews of their respective relatives were held. Moreover, neither of them took any part in any discussion in regard to the merits of his relatives, nor is there anything to show that the marks or credits that are obtained by their respective relatives at the interviews were disclosed to them. So, when the interviews were taking place, they were not in the room, they have not conducted their interviews, they were also not being told about the marks that their relatives have actually secured. Nothing was discussed about their marks or their performance with these people. Now there was no infirmity attaching to the selections that are made by the Haryana Public Service Commission on the ground that though their close relatives were appearing for interview, these two people did not withdraw completely from the entire selection process. So they have refuted this thing. On what ground? You should remember on this ground that they are the important constitutional bodies, and otherwise it will become very difficult for them to function. Okay, the same kind of plea you will see in the Election Commission of India versus Dr. Subramaniam Swamy's case. Now this is a very interesting case, and I think you should read the case in entirety. And it becomes important to read the facts of the case in this case, because otherwise you will not understand as to what has actually happened. Okay, so actually in short, if I tell you, at that particular point of time, 96, yeah, 90 to 96, Mr. T.N. Session, who was the chief election commissioner, he was the part of CEC. Okay, and at that point of time, there was only one in the election commission used to constitute of only one person, and that was the chief election commissioner. TN Session, for your just general knowledge, and I'm sure you must also be aware of this, that he was a great person. Like, he completely reformed the election process in India altogether. No bribe, nothing, everything taking place on the apt time. and he was a no nonsense man, right? So definitely he was not appreciated much in the political sphere. But yes, he has received the Magsaysay award, and in the year 1997 also he fought the presidential election against KR Narayana, although he could not win, but was a man of reputation, so much respected, and has done a lot for the election reforms in India. So in case in 8th semester, if you'll be taking election law, you'll get to know more about it. There is a TN session case, that is a landmark case that we read there. Okay. So, well, apart from that, at that point of time, Miss Jay Lalita, she was there. She has won the elections at that point of time, and she became the chief minister of Tamil Nadu. Now, Dr. Subramaniam Swamy, he has filed a writ petition against Jayalalitha, saying that she has actually violated a constitutional provision wherein it is required that at the time you are an MLA, you should not have any kind of a government contract. It should not be subsisting at that particular point of time. And because it was subsisting, because Jay Lalita was having a governmental contract, therefore she was not eligible to be the CM of Tamil Nadu. Now, Dr. Subramaniam Swamy, he asked the governor to follow the suit and to take the opinion of the election commission in this, because if you read the article 192, it says that governor has to decide the case, but has to compulsorily, shell word is used, he has to take the opinion of the election commission. Now, election commission, as I said, only constituted of CEC at that point of time. So Jayalalitha raised this plea that because Dr. Subramaniam Swamy's wife has once fought the case for TN session, and it was a very important case in the Bombay High Court, and TN session won also. So therefore, TN session would be having a bias for Subramaniam Swamy and against Jayalalitha, and therefore TN session should not be part of the election commission. He should not interfere in the matter. This was the thing. So the matter was being taken to the High Court. The single judge has decided in the favor of Jayalalitha. Then the matter was being taken to the division bench also, again decided in the favor of Jayalalitha. Then the matter was being taken to the Supreme Court, and then finally Supreme Court, applying the doctrine of necessity, held that if you read Article 324 carefully, it very specifically states that the election commission shall comprise of chief election commissioner and other election commissioners. So therefore, if you remove, or if you'll ask the chief election commissioner to recuse himself, then the election commission cannot function. It's very necessary that CEC should be there. Okay, so on that basis they allowed TN session to be a part of it and decide the case as to the qualification or disqualification of Miss Jayalalitha. Okay, this is in short. I've told you the facts and the decision and reasoning of the court. Let's in detail read the case. It's important and very interesting as well. Now, this is an appeal that is preferred by the Election Commission of India and Sri T.N. Seshan, who is the Chief Election Commissioner, against the decision of the Division Bench of the High Court of Madras, which has reversed the view taken by the learned single judge of the High Court. Yes, in 1993, and it held that in view of the promulgation of the ordinance, the doctrine of necessity was no more attracted and applicable in the facts and circumstances of the case. The question raised in the appeal arises in the backdrop of the following facts. Now, further, the two things are here. First thing is that the division bench has overruled the decision of the single bench in one respect, and that respect was single bench judge has decided that Jayalalitha, she was not disqualified. So the court has also decided with respect to her qualification or disqualification. So when the matter came to the division bench said sorry, the court was having no jurisdiction. It was having no right or authority to decide that qualification or disqualification. This is something to be decided by the election commission and the governor. So therefore court should not have interfered there. But as far as the bias is concerned, yes, definitely the facts definitely show that there was a reasonable apprehension of bias. So on that fact, they have the division benches reverse the decision of the single judge bench, but has confirmed this thing that yes, bias as was being observed by the single bench, the same thing was being observed by the division bench also. Okay, so only on one ground the decision is being reversed, so please don't get confused when reversed is being written here. Second thing is they're talking of the ordinance. Now, as I said, at that point of time, only the CEC was the part of the election commission. The president passed an ordinance, and by way of that ordinance, now the election commission was comprising of not only the CEC but of other election commissioners. Now, the doctrine of necessity, it says that if you have other alternative available to you, right? So in that case, you should follow that alternative. So doctrine of necessity should be applied in very specific and very limited cases. When in the beginning I said when you have no other option and the circumstances are unavoidable, then only you apply the doctrine of necessity. And in the first case also we saw that the doctrine of necessity was not being applicable there, because the commanding officer, if even if he'll not be a part of uh, the the bench that will decide his case of court martial, it will function. But the doctrine of necessity will be applicable only when the case will completely become dysfunctional and become very difficult to decide it, and there is no other person who is competent. So therefore one of the plea in this case was, now there are other election commissioners, so the other election commissioners are competent and they can decide the case, and therefore there was no need of CEC. So this was also one of the contention that was raised in this case. Let's read further. Now, Ms. Jayalalitha was elected to the Legislative Assembly of Tamil Nadu on the AIDMK ticket in the general election in 1991, and on being elected as the leader of the party, she was sworn in as the CM on this date. And then as I said, Dr. Subramaniam Swamy, he preferred a petition to the state governor under Article 192, alleging that the chief minister had incurred a disqualification of being a member of the legislative assembly of the state, in that she, being a partner in the partnership firm running in the name and style of Messrs. Jaya Publications, had entered into a contract with the state government, and which contract was subsisting on the date of petition, in view of subclause E of clause 1 of article 191 of the constitution, read with section 9A of the RPA 1951. तो यहाँ पर वी हैव एक्सट्रैक्टेड 191, जिसका आपको क्लॉज ई पढ़ना है, और 9A. तो 191 क्या कहता है? इट सेज अ पर्सन शैल बी डिस्क्वालिफाइड फॉर बीइंग चोजन एज एंड फॉर बीइंग अ मेंबर ऑफ लेजिस्लेटिव असेंबली और लेजिस्लेटिव काउंसिल ऑफ अ स्टेट if he is so disqualified by or under any law made by the parliament. And which is the law? The law is the Representation of People Act 1951. उसका section 9A क्या कहता है? It says a person shall be disqualified if and for so long as either subsist a contract enter into by him in the course of his trade or business with the appropriate government for the supply of goods to or for the execution of any work undertaken by that government. तो अगर contract subsist करता है और आप साथ में MLA भी हो, then in that case will be disqualified. So this was the contention of Subramaniam Swamy, and he raised this thing, and therefore he asked the governor to decide. Now governor did not to the election commission, so he moved the High Court that you should direct the election commission to decide the case on this particular matter. Now, then these writ petitions, they came up for disposal for the learned single judge of the High Court, and he allowed the first writ petition, holding that evidence that is placed on record clearly established that. Now, what he has to say, that Ms. J. Jayalalitha's apprehension that Shri Seshan may not be able to take an impartial view because of his strong bias in favor of Dr. Swamy could not be said to be misplaced or unreasonable, and would be just, fair, and proper to issue a writ of prohibition against Shri Seshan to refrain from expressing any opinion on Dr. Swamy's petition alleging disqualification, since at the relevant time the election commission was a one member body, जैसे मैंने बताया, On the plea based on the doctrine of necessity, the learned judge observed that while the principle of natural justice may have to yield in favor of doctrine of necessity, it was not obligatory to invoke the said doctrine in all cases. In particular, in case on hand, since it was not obligatory to invoke the said doctrine in all cases, uh, and in particular in case on hand, since it was permissible under Article 324 of the Constitution to appoint an additional election commissioner who, if appointed, would constitute an alternative forum for dealing with the matter. तो सिंगल जज ने तो इस ग्राउंड पे डॉक्ट्रिन ऑफ नेसेसिटी अप्लाई नहीं की कि 324 को अगर हम पढ़ें तो वो ये बोलता है कि देर इज़ अ पॉसिबिलिटी दैट इलेक्शन कमीशन मे कंप्राइज ऑफ अदर इलेक्शन कमिश्नर्स एज वेल. तो उस टाइम इलेक्शन कमिश्नर्स थे नहीं, लेकिन उनका मानना था कि और इलेक्शन कमिश्नर्स को अपॉइंट किया जा सकता है जो ये केस डिसाइड कर सकते हैं, और इसलिए जो कंटेंशन था बायस का फ्रॉम द साइड ऑफ जयललिता वाज बीइंग एक्सेप्टेड बाय द सिंगल जज इन दिस केस. अब डॉक्टर स्वामी ने एसएलपी फाइल किया सुप्रीम कोर्ट ने उनको डायरेक्ट किया कि आप जाके आप जाके डिवीजन बेंच के सामने हाई कोर्ट की केस फाइल करो, वी विल नॉट बी हियरिंग यू. फिर डॉक्टर स्वामी केस लेके जाते हैं हाई कोर्ट में. अब एट दिस स्टेज देयर इज अ डेवलपमेंट, एज आई सेड दैट द प्रेसिडेंट ऑफ इंडिया ही promulgated an ordinance and it entitled the chief election commissioner and the election commissioners to be a part of the election commission. अब डिवीजन बेंच का क्या कहना है, लेट्स कम टू दैट. Division bench of the Madras High Court, which heard the appeal, raised 3 points for determination, namely, first, whether the learned judge was justified in examining if Ms. Jayalalitha had incurred the disqualification that is set out in Article 191, read with 9A of the RP Act. Second, whether the apprehension of bias that is entertained by her against Shri Seshan had reasonable basis. And third, whether the doctrine of necessity stood attracted after the enactment of ordinance of 1993. ठीक है, तो ये 3 क्वेश्चंस थे जो हाई कोर्ट को डिसाइड करना है. अब डिवीजन बेंच ने क्या कहा विथ रिस्पेक्ट टू ऑल दीज क्वेश्चंस, लेट्स रीड दैट. As I said that as far as whether Ms. Jayalalitha has incurred any disqualification or not, the court said that it was not for the single judge to decide, and therefore they set aside the ruling of single judge's decision in this case. As far as the issue of bias was concerned, on that fact they have approved the decision of the single judge and said that Mr. T.N. Seshan should be prohibited from participating in the case. And also on the doctrine of necessity, it was being said that now because you have other election commissioners, so doctrine of necessity will not apply in this particular case. Now let us see what the Supreme Court has to finally say, because now T.N. Seshan and Election Commission was being aggrieved by this decision of the division bench, and therefore they moved by an SLP to the Supreme Court. ठीक है, तो बायस के बारे में कोर्ट कहता है, they have this observation that having regard to the close and intimate relationship between Dr. Swamy and Shri T.N. Seshan, apart from the fact that Formus 5 is latter's lawyer in the rupee 1 crore damage suit filed by him in Bombay, the apprehension of bias in the mind of Ms. Jayalalitha can't be said to be misplaced, and her fear that she may not get justice if the decision is taken by Shri Seshan can't be brushed aside as imaginary. तो ये बात तो वो भी एक्सेप्ट कर रहे हैं कि जो बायस का जो स्ट्रॉन्ग फीलिंग है मिस जयललिता का, वो मिसप्लेस तो नहीं है, दैट इज़ समथिंग राइट, बट डॉक्ट्रिन ऑफ नेसेसिटी यहाँ अप्लाई होगी. Now, this further said, we must have a clear conception of doctrine. It's well settled that the law permits certain things to be done as a matter of necessity, which it would otherwise not countenance on the touchstone of judicial propriety. Stated differently, the doctrine of necessity makes it imperative for the authority to decide and consideration of judicial propriety must yield. It is often invoked in cases of bias where there is no other authority or judge to decide the issue. If the doctrine of necessity is not allowed full play in certain unavoidable situations, it would impede the course of justice itself, and the defaulting party would benefit therefrom. Take the case of a certain taxing statute which taxes certain perquisites allowed to judges. Now they're just giving an example. Okay? If the validity of such a provision is challenged, who but the members of the judiciary must decide it? If all the judges are disqualified on the plea that striking down of such legislation would benefit them, a statement situation may develop. In such cases, the doctrine of necessity comes into play. मतलब एक एग्जाम्पल क्या दे रहे हैं कि सपोजिटली आपको एक लॉ की वैलिडिटी डिसाइड करनी है जिसमें यह है कि सारे जजेस को टैक्स पे करना है इन सिंपल टर्म्स. तो जब ये मैटर जजेस के पास में आएगा तो जजेस तो उस लॉ को स्ट्राइक डाउन ही करेंगे. ऐसा सोचकर हम ये तो नहीं कर सकते हो कि उस लॉ की वैलिडिटी को चैलेंज करने के लिए हम कोर्ट में लेकर ही नहीं जाएंगे मैटर. अगर हमने पहले से ये सोच रखा है कि जजेस तो भाई इसको स्ट्राइक डाउन ही करेंगे क्योंकि उनके फेवर में तो नहीं है ये लॉ. ठीक है, तो इस तरह से तो कोई केस डिसाइड ही नहीं हो सकता. That is why they are giving such example, which is against them only. So if all the judges are disqualified on the plea that striking down of such a legislation would benefit them, a statement situation may develop. In such case, the doctrine of necessity, it comes into play. If the choice is between allowing a biased person to act or to stifle the action altogether, the choice must fall in favor of the former, as it is the only way to promote the decision making. ठीक है, जब इस तरह की सिचुएशन आए कि बिल्कुल ही डिसाइड ना करने से अच्छा है कि कुछ तो डिसीजन लिया जाए, तो इट्स बेटर कि हाँ कुछ डिसीजन लेना ही चाहिए. इस केस में भी जो लोगों का कंटेंशन था फ्रॉम द साइड ऑफ जयललिता, दैट नाउ देयर आर 2 इलेक्शन कमिश्नर्स आफ्टर द coming of the ordinance and they can decide it. So there also there is a practical difficulty. What's that difficulty? Now supposedly the 2 election commissioners, if they come to a unanimous decision, there is no problem, right? Therefore that they're saying there's no need of chief election commissioners to participate. If not, then the doctrine of necessity may have to be invoked. We think that is the only alternative in such a situation. We are therefore of the opinion that the proper course to follow is that the chief election commissioner should call a meeting of the election commissioners to adjudicate on the issue of disqualification of Ms. Jayalalitha on the grounds alleged by Dr. Swamy. And after calling the meeting, he should act as the chairman, but then he may recuse himself by announcing that he would not participate in the formation of opinion. In simple terms, उनका suggestion ये था कि इलेक्शन कमिश्नर्स को इस केस में डिसाइड करने दो मैटर. अगर वो एक यूनानिमस ओपिनियन पर आते हैं तब तो कोई प्रॉब्लम नहीं है, तब वो बात रख ली जाएगी. लेकिन अगर उनकी कॉन्ट्रैरी कन्फ्लिक्टिंग ओपिनियन होती है तो उस केस में जो डिसाइडिंग वोट होगा वो चीफ इलेक्शन कमिश्नर का होना चाहिए. और ये जो है इस तरह का जो फॉर्मेट है वो हम डॉक्ट्रिन ऑफ नेसेसिटी के बेसिस पर इसे अप्लाई कर रहे हैं. डॉक्ट्रिन ऑफ नेसेसिटी के बेसिस पर हम इसे अलाउ कर रहे हैं दैट इट शुड बी डन, अदरवाइज देयर इज नो नॉट अ पॉसिबिलिटी टू डिसाइड द केस. ठीक है, दैट्स all that is being said in this particular case. And then there is next case of Justice P.D. Dinakaran versus Judges Inquiry Committee. This is the case where doctrine of necessity actually is not being applied in a strict sense. In short, if I tell you the facts, actually Justice P.D. Dinakaran, he was the former Justice of the Karnataka High Court, Chief Justice of the Karnataka High Court, and there were allegations of corruption against him. He was the Chief Justice of the Tamil Nadu High Court, and there were allegations of corruption against him. So there was a Judges Inquiry Committee that was being formed. In that Judges Inquiry Committee, there was the senior advocate P.P. Rao who was there. He was having problem with the senior advocate P.P. Rao. Why so? Because there was a meeting that was being organized by P.P. Rao against this person, saying that there was not a meeting, I'll say this is just a kind of a there was a kind of a discussion that was being taking place with respect to the thing that now, because many members of bar was opposing his continuation as a judge, therefore he should resign from his post. So he also supported the same thing, and he has in fact taken a delegation of all the lawyers against the collegium's decision to elevate him to the Supreme Court judge, because collegium has decided to elevate him, and at the same point of time there were allegations of corruption against him, that he has actually taken some property, some public property, he has encroached public lands. So when such kind of allegations were there, he should have resigned from his post, and he also supported the same idea. So when judges inquiry committee was being formed and he was a member of it, at that point of time, uh, Mr. Justice P.D. Dinakaran, he raised an objection. The problem is he did not raise the objection then and there. The problem is that when he came to know that P.P. Rao is a member of the Judges Inquiry Committee, he went to Mr. P.P. Rao to meet him personally at his residence, and therein he said that he just showed his concerns that just before his elevation, and till the point of time of his elevation, he was appreciating Justice Dinakaran as to what certainly happened, and how he is also believing other members that he has involved in corrupt practices. This is not true. So he was trying to kind of influence him in a way that he's not being involved into any corrupt practice, and he should not be a part of this propaganda. So PP Rao, he said that don't worry, and whatever we are doing is in your benefit, and therefore don't think as if I am against you. Now these words of PP Rao actually assured him now that now PP Rao is not having any bias against him, so therefore he did not raise any objection when the Judges Inquiry Committee was being formed, and he was a member of it. But there were other people from the opposite party. They were saying that when P.T. Dinakaran has actually went to meet P.P. Rao, and P.P. Rao has given him some advice, therefore P.P. Rao is having bias in favor of P.T. Dinakaran, and therefore he should not be a party. So you see, both the sides were raising contention. Some of the people were saying that P.P. Rao was having good relations with P.T. Dinakaran, therefore he should not be a party to it. And P.T. Dinakaran, he raised later an objection that because he has led a delegation against me and has spoken about me, which is in contrary to my position, and therefore he should not be a party to it. Well, when these things were being highlighted to the chairman of the Judges Inquiry Committee, and chairman, you know, that chairman of the Rajya Sabha, so he said that P.P. Rao she should continue as a part of the Judges Inquiry Committee because of the stature that he was having. He was an expert, and because of the kind of legal acumen that he possesses. So, chairman wanted him to continue. And later, therefore, he even sent his recusal saying that I'll not be a part of it. But chairman said, no, you should continue to be a part of it. Well, all this happened, and when the charges were being framed against him, then he raised the contention that the P.P. Rao should not be a part of it. So, as far as P.P. Rao's continuation was being concerned, the court in this case said that definitely this is something which is raising a clear bias. Even a reasonable man would think that it is something against the principle of rule against bias, and therefore Mr. P.P. Rao should not have continued, even though howsoever impartial he may be. But on the ground of necessity, the charges that were being framed against him by the Judges Inquiry Committee, in which P.P. Rao was also a member, they were not being quashed in this case. However, the court suggested that instead of P.P. Rao, some other member should be substituted in the Judges Inquiry Committee. That was the final decision. Okay, so this is all about these cases, which will let you know that sometimes we follow the doctrine of necessity when the circumstances are unavoidable and it's necessary to deliver justice not by the clear and very specific and rigid terms of judicial propriety, but yes, justice in the sense that it should be delivered rather to be delayed and denied. Justice should be given to the parties, but yes, this doctrine applies in very limited circumstances when you prove that there was no other alternative available to you. Okay, so this is something which is very important. And so till now we have read, I think, 14 cases, like starting with the application of the principles of natural justice, and I think we read 4 cases in that: Iki Krayapag, Dina Pani, Ridge versus Baldwin, and Cooper versus, and the H case, and 5 cases. Okay, 5 cases there. Then we read, I think, 2 cases each: personal bias, pecuniary bias, and institutional bias. So 6 plus 5, 11. And then we have read 4 cases today, that is with respect to doctrine of necessity. So I think 11 plus 4, 16. Right, so in total I think there were 16 cases. So I think you should be reading these cases. Please read the PDF, and please listen to the lectures. If you have any doubt, please, I am always available at any point of time. Put your message on the group in the Google Classroom, and I'll definitely revert back. Okay, all wish you all the best. Take care of your health. Take care of your family members. Bye bye.